2. One, two. Yeah, with me. Can you settle down? Good morning. Good morning, everyone. Good morning to the department led by the minister. Good morning to the members of the committee. My name is Siyabamkela Mthonjeni. I'm the committee secretary of this committee. We have an apology from our chairperson who is not well today. In accordance to Rule 159 of the National Assembly rules, we therefore have to elect an acting chairperson in the interim that the chairperson is not able to function, to conduct her functions. I am going to call and open the floor for nominations. And then if there are more than one nominations, we can put the names to the vote for the person who's going to be the acting chair for today. This is me now opening up the floor for nominations. Honorable Sokopo. Honorable Sokopo, can you speak to the record, please? Thank you. Sorry.
I'm Sokopo nominating Honorable Engelbrecht to stand in as the chair.
Can we get a seconder? Honorable Daniel, second the name. Thank you. Honorable Engelbrecht, are you available?
I am, thank you.
Okay. Are there any further nominations for the chairpersonship, for the acting chair? Okay. In the absence of any further nominations, I declare Honorable Engelbrecht as duly elected as the acting chair. Thank you. You may assume your seat.
Thank you very much. Welcome from my side, the members, Minister, and the department. Welcome. The purpose for this meeting would be to receive a briefing from the Minister concerning the process leading to the revocation of parole for parolees, and also a briefing from the department relating to the overhauling of the parole system, including filling vacancies on the parole board. Is there any other apologies?
Okay, morning once again. We have an apology, obviously, from the chair, who's not well, and we also have an apology from the deputy minister, who's making her way to this meeting. She's on her way from the airport. That's about it from my side. Thank you.
Thank you very much. I don't know if it's necessary that we introduce ourselves, because I think everyone here has been working with each other for quite some time, so trying to save time, I would ask the Minister to continue with his presentation on the revocation of the parole. Thank you very much, Minister.
Thank you, Honourable Chair, Honourable members. Firstly, I just want to mention that the National Commissioner is on a international conference in Morocco, and the acting National Commissioner is the CDC. And those, you know, there are so many abbreviations. It's the Chief Deputy Commissioner, Anna Molepo, who is acting National Commissioner at this moment. So she will do with a team the presentation on the process of the revising of the parole system, and she will introduce her team. From my side, I have here at my back my Chief of Staff, Mr. Peter Kilian. Then I have an announcement to make, and that is my media liaison officer as well as my PA. She was, you know, Ulofsson, but since the 2nd of May, she's now Mrs. Unai Wessels. So we can congratulate her on her wedding. And then I also have my parliamentary liaison officer, that is Vuyo Laku, and that is from my side, my team. Chairperson, thank you from my side. To give you the presentation, we have distributed the presentation before the time. In short, when you look at the contents, I just want to make sure that we are on the same page. You can see it's our purpose, the legal mandates. Must I move to the middle, the center? Okay. All right. And as you can see, what we're going to deal with, the purpose, of course, is to appraise the Portfolio Committee on the process leading to the cancellation or revocation of parole for parolees, including criteria used in identifying which parole to revoke. The relevant, I'm on slide 4 now, with relevant legislation and sections is, of course, of the Correctional Services Act, Act number 111 of 1998. We will deal with the section 73, 75, and 78. And if we look at section 73, deals with the length and form of sentences, and it is important that we take note. It states that subject to the provisions of this Act, a sentenced offender remains in a correctional centre for the full period of sentence, and specific when it comes to lifers, because this is what this presentation is about, it's about lifers, that are people who have been sentenced to prison for life. An offender sentenced to life incarceration remains in a correctional centre for the rest of his or her life. That is important, that we know that it is. And it says, subsection 4, in accordance with the provisions of this chapter, a sentenced offender may be placed, not must, may be placed under correctional supervision, day parole, parole, or medical parole before the expiration of his or her term of incarceration. So it's very important. If you're sentenced to life, you are sentenced for life. And it is not that you are entitled to receive parole. You may receive parole. If you look at 73, section 73, the length and form of sentence, a sentenced offender may be placed under correctional supervision on day parole, parole, or medical parole, on a date determined by the Correctional Supervision and Parole Board, or, in the case of an offender sentenced to life incarceration, on a date to be determined by the Minister. So it says specifically when it comes to lifers, it is determined by the Minister. If we look at slide 7, apology, when it comes to parole, lifers are not automatically entitled to be placed on parole after serving a minimum detention period. Lifers are placed on parole or day parole after approval by the Minister, after considering the profile report, together with the recommendations of the Case Management Committee, the Correctional Supervision and Parole Board, and the National Council for Correctional Services. Parole is a privilege and not a right of offenders, a right offenders can lay claim to. And I quote on a court case of the plea against the Minister of Justice in 2015, a parolee remains at all times a sentenced prisoner and has no right to parole. Close quote from the court. When we look at Section 75, subsection 6, when the board or the minister cancels correctional supervision, day parole, parole or medical parole, the matter may be reconsidered by the board or the minister within such period as the board or the minister deems fit, but the board or the minister must do so within 2 years. It's very important. Section 75, subsection 9, the minister may cancel correctional supervision, day parole or parole as referred to in subsection 6, only if the decision to grant correctional supervision, day parole or parole was taken by the minister. Just to give a bit of clarity on that. That means if a lifer is on parole, then it is quite clear that only the minister then can, for instance, decide to cancel that parole, but that must happen within 2 years when the person or the prisoner then went on parole. And what is important, subsection 9, it can only happen if the decision to put the lifer on parole was taken by the minister. So that is important. We must understand that. So within 2 years, because I receive messages and say, why don't you bring back, for instance, Shabir Sheikh and all that sort of things. But after 2 years, then you cannot cancel, well, if it is a lifer. Then when it comes to the powers of the Minister for Revocation, Section 78, subsection 3, where the Correctional Supervision and Parole Board acting in terms of Section 73 recommends, in the case of a person sentenced to life incarceration, that parole or day parole be withdrawn, or that the conditions of community corrections imposed on such a person be amended. The Minister, on advice of the National Council, must consider and make a decision upon the recommendation. 78, subsection 4, where the Minister refuses or withdraws parole or day parole, the matter must be reconsidered by the Minister on the advice of the National Council within 2 years. It's actually a repeat. The common reasons for revocation and withdrawal of parole or day parole, each case, of course, is considered on its own merits. It's very important. When it comes to revocation, for instance, examples is failure to comply with parole conditions, such as, but not limited to, alleged commission of crime whilst on parole, found guilty of commission of crime whilst on parole, absconding, not found at fixed address, loss of support system. Those are examples. Normally, it is general that when you are on parole, you're not allowed to use any alcohol. And that's also, we have lots of problems when it comes to that precondition. When we talk about withdrawal, the commission of crime before parole date, that's of course certain conditions, and commission of disciplinary offences before parole date. In short, if we look at slide 11, it clarifies the process for revocation for lifers. Of course, it starts with a warrant issued by the community corrections due to violation of parole conditions after investigation or change of lifer circumstances. Then the supervision committee or the head of the community corrections makes a recommendation on revocation of parole. Recommendations for revocation are considered by parole board, and the recommendations for revocation are considered by the NCCS, and the recommendations for revocation are considered by the minister. So that is the whole process. It goes through that. When it comes to the process of cancellation of lifer's parole, then it is done in terms of the under-mentioned provisions, and I've said it before, 75 subsection 6. I'm not going to read it, everything, we've read it just now, and 75.9, where we say the minister may cancel if the decision to grant correctional supervision was taken by the minister. The reasons for cancellation, it's important. Non-compliance with consideration process when parole was approved. Lack of victim participation in terms of Section 299A of the Criminal Procedure Act 51 of 1977. Non-compliance with a non-parole period set by court. It is very important to note that the victims, they are playing a very important role when it comes to the granting of parole. And as I've read there, and if you can see, if we can only approve if, for instance, there was victim participation, the lack thereof then gives a reason for cancellation. Sorry. Another, of course, no NCCS recommendation is required. NCCS, of course, is the National Correctional Services Commission. No NCCS recommendation is required. The decision of the board or the minister is subject to the PAIA, the Administrative Act, and each case is considered on its own merits. So that in short, Honourable Chair, can I just say on the PAIA, I can also say that normally the process is, my apology, that you also send a letter to the person explaining also the reasons why you want to cancel the parole. The parolee then has an opportunity to object to that. So we had a process of that, and we have complied to all that, can I say, preconditions. So that, and I always say that if I take a decision whether I have to approve or reject an application, I always ask myself, if you go to court, well, you can be able to answer in court. So all the decisions I take as a minister when it comes to lifers, I ask myself that I must be justified to stand in the court to ensure that I comply to the rules, and I can say to the committee that we are complying to all the legislative requirements. So, Honourable Chair, that is as far as the lifers are concerned. I don't know whether there are you going to deal with it? Questions now, we're going to deal with the other side and then the questions, but it's in your hands. Thank you.
Thank you, Minister, for your presentation. I think let's handle this one agenda item at a time. I think that I would like to hear from members if there's any clarifying questions or remarks. Let me just, please put up your hand that I note you. So we're going to have Honourable Nias, Klute, Gaza, Plaatjes, Honourable Nkaba, and Honourable Daniels, and Honourable Sokopo, in that order. Thank you very much. Honourable Nias.
Thank you, Chair, and let me first of all thank the Minister for the presentation on parole and revocation of parole for lifers. Chair, I first want to make a statement, and this is something that I've said before. I'm of the conviction that there are certain crimes that are so serious that parole should never be granted. And I'm of the conviction that the statements that are made by the sentencing judge with regards to such crimes should be taken into consideration. Now, Chair, the Minister presented to us the basic understanding that anyone who receives a life sentence is never really released, remains under the custody or the control of the state and the Department of Correctional Services. So someone who receives a life sentence is supposed to be for his or her life under parole and control of the correctional services system. Chair, of course, there have been some very serious precedents that did not allow this. And I think the Minister knows where I'm going. I want to talk about Janusz Wallace, because the case of Janusz Wallace contradicts the presentation that we received here this morning. First of all, Wallace had a life sentence. Secondly, the victims, the family of Commander Chris Hani, who Wallace assassinated, killed, specifically the wife of Commander Hani, Ms. Dimpu Hani, had made it very clear that she did not want Wallace to receive parole. Despite the family having been on record making that crystal clear, a decision was taken by our Constitutional Court, and specifically the former Chief Justice, Mr. Justice Zondo, which indicated a reading of the law that says that Wallace was entitled to parole, and that the objection of the victims, in this instance Commander Hani's family, was not the determining matter. Now, Chair, the circumstances under which Wallace was released meant that he was not being placed under permanent control of the correctional services system. Because within 2 years after his release, he was allowed to be deported to Poland, and Poland being an independent country, the Department of Correctional Services has absolutely no control over Wallace, and if he breaks the parole conditions as any other lifer would have done and could have been returned to prison, it cannot happen. In fact, we had the unseemly sight, Chair, where Wallace then proceeded to have a very high-profile media interview in which he said that if he gets the chance to do the same what he did with assassinating Commander Chris Hani, he would do so again, which indicates that there was no rehabilitation. So, Chair, we've got a serious problem. There are situations where the way in which the Minister had presented to us parole for lifers had not been adhered to. And the problem is even more serious because this decision on which Wallace was put on parole, despite the objection, and I emphasize it again, of the family of the victims of Chris Hani, despite the fact that he had been put on parole, despite their objection. He had also been allowed to leave the country, which means the Department of Correctional Services cannot continue to control any parole conditions over him. I think this has set a precedent that we will truly rue and be very seriously embarrassed by also in the future. Now, I would like to ask the Minister, would the Minister consider under the circumstances where this was clearly a contradiction of what he presented to us today? Would he consider to approach the Minister of Justice and Constitutional Affairs and also the Minister of International Relations and Cooperation and request them to make a formal request to the government of Poland for the extradition of Janusz Wałęsa back to South Africa on the basis of the fact that Wałęsa had broken South African law, and on the basis of the fact that if he was still in South Africa after that media statement, after that press conference that he had interviewed, he would have had to be taken back into prison because he had broken his parole conditions. He threatened to recommit the same crime for which he was sentenced. So I would like to hear from the Minister if the Minister would be prepared to make such an application. Because I think it is very important, Chair, that we need to re-establish the integrity of the law. And this particular matter of Janusz Wałęsa has undermined the integrity of the law. In fact, it made a mockery of it. Now, lastly, I would like to ask the Minister, while we say that no lifer is entitled, or no one is entitled to parole, how do you interpret the judgment that was done by the former Chief Justice, Mr. Justice Zondo, which insisted that Wałęsa had the right to parole? Because that seems to undermine also that provision that no lifer is entitled to parole. And I conclude my input, Chair, by closing the circle with what I started with. There are certain circumstances, because of these kinds of contradictions, where parole should never be considered. There are certain crimes, no matter what a person says he or she is doing in prison, what kind of rehabilitation there is apparently. There are certain crimes that are so serious, and I consider this particular matter of Wałęsa having assassinated Commander Chris Hani as a prime example of such a serious crime, not just because of the terrible action that he had committed, but because of the terrible consequences that it could have had for the whole of South Africa. We were on the brink of this country descending into an absolute depth of violence because of that. And I'm talking from experience, Chair. I was there. I was attending the funeral of Commander Chris Hani. I saw the emotions that were unleashed by that action. So certainly there should be certain crimes where someone should not be ever given parole or ever given the chance to get out of the system in the way that Janusz Wałęsa had managed to get out of the system, with the assistance, I hasten to add, of the state. And unfortunately, also with the assistance of our highest court, the Constitutional Court. All of these issues raise serious concerns, Chair, about the consistency of the application of parole for lifers, and whether the statement that the Minister made, that life means life in the sense that even if you get released on parole, you still continue to be under supervision of the Correctional Services process for parole. In this instance, it did not happen. Thank you, Chair.
Thank you, Honourable Neus, Honorable Kluter.
Dankie. Eerstens laat me toe om die waarnemende voorzitter te groet. Leden van het parlement, minister, de adjunct minister, allemaal werkzaam bij het departement van correctieve diensten. Eerstens, voor ik die presentation ga verwelkom, laat me toe om die minister te verwelkom. It's been a long time. Yeah, I only have 3 questions regarding the presentation. How much impact does victim participation have on the correctional supervision in parole boards decision making? The second one, Acting Chair, how can the correctional supervision in parole boards determine the risk to the community and the victim and the risk of reoffending when placing an offender on parole? The last one, Acting Chair, is that what are the main factors that influence the correctional supervision and parole board's decision for parole? And I thank you, Acting Chair.
Thank you, Honorable Kluter. Honorable Gaza.
Thank you, Chairperson. The presentation does not address the well-documented delays in processing parole reviews for lifers, leaving many incarcerated beyond their minimum detention period due to bureaucratic inefficiencies. So the 2-year reconsideration period is often ignored. Yet the DCS provide no explanation for these failures. So what specific measurable criteria does the minister use to decide whether to grant, revoke, or to cancel parole lifers? And the second question, why are these criteria not published to ensure transparency and prevent arbitrary decision making? How many parole revocation for lifers have been challenged in court? And what percentage were overturned due to procedural unfairness? How many lifers have been kept in prison beyond their minimum detention period due to delays in period reconsideration? And the last question is, are there any documented cases where parole decisions for high-profile offenders were expedited or delayed due to political pressure? Thank you.
Thank you, Honorable. Honorable Plaatjes, you are next.
Thank you, Chair. Chair, I think on what the Minister presented today, as my colleague Nias have been saying, is that Honorable Nias has been saying, is that there's a serious contradiction in what is presenting today in this committee on the time frame that a lifer must serve before being eligible for parole, and what he's saying that life is life. When you are in prison for life, you are in prison for life. But there's also a minimum sentence that a lifer must serve. I think it's 25 years to be eligible for parole. It's a serious contradiction. I just want you, Minister, to clarify that contradiction between those two, which if actually made reference to case study, to Wallace's issue on the issue of lifers, and also that life sentence parolee remain the property actually of government. That is what you are saying in a nutshell, Minister. Then it becomes a real serious issue if that is the posture of the life sentence parole on that matter, case study itself. When you say a life, even on parole, is still part of your community and you are having actually the last say on what must happen to that person in a nutshell. Then it becomes a more serious issue on what Honorable Nias have raised in that matter. But also, I want to go, leave that one. I also want to go to the aspect of maybe asking you directly, Minister. Don't you find it maybe too much subjective for you as a minister to have total powers in deciding on approving or denying a lifer's parole as a minister alone? I don't see the act giving you a structure around yourself or advisory structure to make that kind of conclusion. So will your decisions not be, as you are saying, you are getting WhatsApp messages, you are getting a lot of inquiries on certain lifers? Is it not going, and can it not cloud your judgment when you are having to oversight over these kind of decisions? So that is mine. So except also, as you are saying, Minister, the only place that can deal with your conviction and your approval or not approval, you mainly refer back to the case itself, because it's from the judge to you. In between, I don't hear you saying anything. What is in between the judge and yourself and making your decision? So, what then, in general, would make you to make the final decision on this issue of parole, of life sentences? Thank you, Chair.
Thank you, Honourable Paikis. And then next we have Honourable NCOP.
Thank you, Chair. So I appreciate what the Minister said about thinking through whether you can win a case before you make a decision. That consideration helps us to stop or mitigate the political influence. The decision, for example, to revoke the parole of Allison's would-be killers is incredibly popular. I support it, but I do have questions around the legal framework that I would like you to expand on. So the request to revoke parole for those gentlemen, where did it start? My understanding of sections 75 and 78, all of them speak to you, the Minister, receiving a request to revoke where it concerns lifers. I don't see anything that empowers a minister to initiate that. So just to be clear, was this a request, for example, from Allison and her reps to yourself, or from other people to yourself, or did it actually come through the National Commissioner and the process set out in the Act? And if you are of the view that I'm misinterpreting the process, please do correct me and point us to the sections you are relying on. And then the next thing relates to the reasons. So I see your slides are gone. On slide 10, there were a list of reasons. It is not clear to me which of those reasons apply to Allison's case. Why? What was the basis for the revocation? If it's not one of the ones on the slide, where is it in the law? Can you just take us through how you came by the reason for revocation? And then the last thing is, in the event, I'm assuming you've got counters to what I'm saying. I would like to know if you've received external legal advice on the validity of your position and process that you've taken? If so, from whom? So that would be outside of the Department for Correctional Services.
Thank you, Honourable. Then next one, Honourable Daniels, you have the floor.
Thank you so much, Chairperson. Good morning, colleagues. Good morning, Minister, Deputy Minister, officials from the Department of Correctional Services. It's always an issue when you have so many learned and seasoned colleagues that speak before you. They cover most of your things. So it's actually a great help also. I've been extensively covered, and it's very interesting when we've not had a caucus the one with the other, to actually, when you hear the others talk, how like-minded you are in your reasoning around these type of matters. So I welcome each and every input that was given, and I'm sure it's in the best interest that all those inputs were given. What stood out for me clearly was that how evident it is that foreigners are truly receiving more kind of a prime treatment when it comes to anything in general in our country, and in this case, also those who apply for parole. We are in full support in checking out the prospects of extraditing Janus Wallace back to South Africa. In particularly, the fact that there's no remorse, in particularly having also looked and listened to his interview where he arrogantly spoke about how he would repeat the crime that he done to Chris Hani. A real liberator in the history of this country. And it was a very sad day when the news broke about the killing of Chris Hani. And I am sure that it cannot settle well with anybody when they reflect on how Janus Wallace is now conducting himself. And on the basis of that, I would say that it would be very welcoming to find out, Honourable Minister, whether we can bring that guy back here. So maybe some of our people can deal with him there inside also, I don't know. But he never deserved to be let out on parole. And if we can come with the merits also around that final decision that granted him the right to make his way back to Poland, that would be very welcoming for us to know. The Minister's report in the main, the subject point of this agenda item, and noting the legalities relating to the criteria in revoking the parole. From where I'm sitting, I welcome the report. When I look at how the Minister unpacked the reasons behind that, what
It's not the final bell.
it's not. Like I said, the report is welcomed. Minister unpacking legislation, the law, what got the Minister to take that decision. I trust that all those reasons cited by the Minister is good enough to have provoked that parole, because we are also in support of the parole being revoked, and we welcome that decision. Being from Nelson Mandela Bay myself, I will never forget the morning when I woke up to that horrendous news of what happened to Alison. And when this decision was taken to revoke the parole of those two hooligans, it was really, really welcoming. I think just about for any law-abiding citizen and others who fell victim and prey to such things, because there are so many unresolved cases so many unresolved murders in this country, that such news is welcoming to those families who today could never still find closure because of matters still being unresolved. And who knows, it's those people and like-minded whose parole has been revoked, who's still out there at large. And we do welcome that. It's just unfortunate that it's a challenging thing to bring back the death penalty, because that will work. I'll be the first one to be there to ensure at the gallows I'll be there without a mask over my face to deal with those people. And I hope and pray that as politicians we'll find the platform to express us readdressing or again discussing the death penalty. Because it's in the absence of corporal punishment and death penalties that we find our beloved South Africa in the state and condition that it is today. It was way different back then when that was still in place. Like it or not, it is what it is. I want to conclude, because I've been covered extensively by everybody else, and just say that I hope that this particular item will assist us in going forward. And I trust, and I pray, and I believe that if there is anything wrong with, or any flaws in the decision taken by the minister, that mistakes would be identified, pointed out, highlighted, and found that such flaws or mistakes, should it be the case, are then vested within our system so that we can amend the systems to make sure that everybody finds comfort when such decisions are taken by the minister. Because I cannot believe that it's a personal decision taken. It's guided by legal opinions and what we have before us as presented by the minister. I thank you.
Thank you, Honorable Daniels. Next, we have Honorable Sokopo, and after him it will be Honorable Diale.
Oh, thank you, Chair. I welcome the presentation by the Minister. Minister, considering that the authority that you have, it's clothed by the Correctional Service Act of 1998, taking into account that a retrospective application is not allowed by law, how do you deal with those that has been incarcerated before the promulgation or the implementation of the law, of this act that have given you the power? I think Honorable Niaus and Honorable Plachis have covered me very well. In your report, you are saying that lifers are a property of the state. Then the question is, how do you deal with those that are lifers, are not South Africans? What would have been the appetite in an event that they leave the country, go to any other country, and commit a crime in that country? Will that count to you in South Africa? Because if it would have been a South African, then you would have revoked that person's parole or so. So I really want to check on how we are going to deal with it. I think I don't want to harp a lot on what Honorable Niaus have raised, and I have appetite. You make mention of Shabir Sheikh, that is more than 2 years that you, I'm sure what you are raising there is that there's nothing that you can do. It's out of your thing because of the duration of time. And what Honorable Niaus is harboring on the Walus case, it is within your time, your appetite, and on attending to it. I'm sure it will assist this committee and the country. I thank you.
Thank you, Honorable Diale.
Thank you very much, Honorable Chair. Perhaps I need to, let's get to I need a specific in respect of the release on parole of Janus Walus. if the minister can explain to us specifically what are the conditions for his release, the specific conditions for release of Janice Walus, and more importantly, how is the department, what measures are in place for the department to monitor Janus wherever he is? Secondly, perhaps the minister, if you can just give us an indication, you were appointed minister in July last year. Since the inception of your term, can you give us an indication as to how many paroles were granted by yourselves and for who? The names of those, if you have. And perhaps how many paroles were revoked by yourselves? Most probably those that were granted by your predecessor in the department, if we can get those. And lastly, what informs your decision in each case, especially the revocation of paroles? What are the decisions or the reasons for you to revoke those paroles? And how were those matters identified? How did you identify paroles that you needed to revoke in respect of each particular parolee? Thank you.
Thank you, Honourable Diale. And just before I hand over to the Minister, Minister, from my side, I understand that lifers are not automatically entitled to parole. And however, we have numerous court cases that I know personally of, where lifers took correctional services to court, and the court order was issued to release or to consider a parole. So, just for clarity's sake, isn't this rather a process that consideration needs to be given under certain conditions, where, you have the minimum sentence that has been served as one of the conditions, and then there needs to be how do you say it, a record of decision should an inmate feel aggrieved and goes to court, and the minister can then provide a record of decision as to what steps were taken and what exactly led to denying parole or revoking parole or that. And then there's a common theme in all the questions asked by honourable members. Yeah, there's a disconnect, I think, between the judiciary, Department of Justice, and unfortunately Correctional Services has to bear the brunt, because people understand that we stand at the end of the criminal justice chain, where a court issues an order, and what do? You appeal, you lose your appeal, you do what it says, and that's it. From your side, I want to know, has there been high-level engagement on ministerial level or on the level of the Chief and the Chief Justice to sort out once and for all? And it's not only parole, it has to do with the tremendous amount of remand detainees that we sit with, and they just keep sending these, and they have a criminal case backlog of more than 50,000, and all of that is dumped on correctional services, decimating our budget, and all the bad press emanating from very bad decisions taken by either the judiciary or Department of Justice not doing what they're supposed to do, comes down on DCS, which I think is very unfortunate and very unfair. What is the type of engagements? How regular is those engagements? And what do you see, or how long would it take until such time that clarity can be found in terms of these processes that we continuously find in this portfolio committee? That's all from my side. Thank you very much. Minister, over to you.
Thank you, Honourable Chair. Chair, what I'm going to do is I'm going to deal with the Walus matter, just to give clarity on that, and then I will give a approach to the reasons for the decisions. And I think that by that I will answer quite a lot of the questions, but I will go through the questions and I will try to answer each and every one. Now, firstly, and I hear about the Janus Valus case, and I hear about just what we said in our presentation in terms of the 1998 Correctional Services Act, life is life. What we did not put in the presentation is, and there was a question, I think it was Honorable Sepoko or someone that said, what happened before 1998? Now, what happened before 1998? There was another constitutional court case, and that was, it is known as the Van Vuren case. Now, on the 30th of September 2010, the Constitutional Court handed down judgment on the matter of Van Vuren versus the Minister of Correctional Services and others, and this ruling brought about a change in the manner in which inmates sentenced to life incarceration before 1 October 2004. So it's a very important date, before 1 October 2004, were considered for placement on parole. The minimum detention period for inmates sentenced to life before 1 October 2004 was indicated to be no longer a blanket 20-year period. So, before 1998, in fact, if we go before 1 October 2004, if you get life, it was actually 20 years. It's a blanket 20 years. That is what it was. And then, Van Vuren cases, those are the life sentences before 1 March 1994, were considered for parole placement after serving 10 years. However, placement on parole could only happen before serving 15 years if they were exceptional circumstances. Over 360 lifers benefited from the Van Vuren judgment. This category of lifers is not considered by the NCCS. Van Vuren Advisory Panel, constituted by the DCS members, considers these cases and submit recommendations to the Minister. These lifers are placed on parole for a period of 3 years. Before 2005 and 2012, special remissions are deducted. So the National Council of Correctional Services, in fact, not even they make a decision. There was a specific, and it's still, a Van Vuren Advisory Panel that makes a recommendation. So, in the case of Janus Walus, he's a typically Van Vuren case, because I think he committed the crime in 1993, if I can remember. So, what happened? Firstly, as Minister, I can only comply to court findings and the law. In Walus's case, it was before my time, but that doesn't matter. It is a matter that it was a constitutional court decision. Now, I'm not going to argue about the reasons for the judge's finding or the constitutional court's finding. The fact of the matter is, it is a crime committed before the 1998 Act. The Constitutional Court determined that he is on parole. It was 3 years. And after those 3 years, in simple terms, it actually meant that he served his sentence. And then what happened is, and because he was on parole, it was still the responsibility of correctional services to ensure that he complied. But when it came to the end of his parole term, then, and it was taken to Cabinet as well, to say, and we from Correctional Services said it is a high-profile case. So just take note that on that date, and I think it was in December, if I can remember, then our responsibility from Correctional Services as far as Janus Valus is concerned are completed. It's out of our hands. And that's why he was also deported back to Poland. So if I can answer some of the questions of Honorable Niehaus, the family did not want parole and everything. We must be objective, and I will refer to the matter of objective or subjective. It is not a matter that if a family or a victim, let's put it a victim, or the victim's family, if they feel that the person cannot go on parole, that the person cannot go on parole. There are emotions, normally quite understanding, and I'm talking about lifers. Normally it's in most of the cases it's murder, robbery, and these days rape. So it's an emotional situation. That's why you have the law. You have to look at a specific criteria, and I will come back to that criteria because there was a question on that. So to ask me whether I will consider to approach the Minister for Justice and International Relations, because it's about the integrity of the law, I think you're going to lose your case. Because I have explained, it's a matter of a Van Vuren case. It has complied to the law, and I mean, he actually served his sentence. So that is as far as the Walloos case is concerned. Let me come back to the process before I come to the Alison Botha matter. Now, what happens when I have to make a decision? Firstly, there is a process. You get the Correctional Supervision and Parole Board. They go through the profile of the applicant or the parole application. That involves psychological interviews and a report, even a criminologist. It is also looking at the case management center's report. And very important to me is the risk analysis of reoffending of the applicant. It also states, for instance, of course, all the detail, personal detail, and the sentence, what the judge found, and also what the specific contravention of the law is concerned, and what the act is. Those are all in the profile. So now the supervision and the parole board now looks at this profile, and then they make a recommendation. And then, of course, it goes to the National Council for Correctional Services, the NCCS. They look to the same profile, and then they make a recommendation. It can differ from the parole board, or say, for instance, a parole board recommended parole, then the NCCS can decide also to recommend it or not. And then I receive those two reports as minister. And then I go through the whole file again and the profile of the applicant. And then I make a final decision. I will give the statistics just now in terms of how many I have approved and rejected and all that sort of things. And on that, I make, and let I put it very clear, it's not a subjective decision. I don't know even the name, well, I see the names, but I don't know the people. For me, it's the statistics, what happened, and I can put it very bluntly here, for me, it is very, very important. What is the risk of reoffending? Our recidivism rate in South Africa is much too high. So for me, that is very important. And I say it openly. And I know what we are saying here, some can use it in a court case. But if the risk is moderate to high, I then request a further profile, say after 12 months or 18 months or 24 months. Then, for instance, I want a proper risk analysis. And why do I say that? Honourable Chair, it is sometimes disturbing to see what crimes are happening in South Africa. If I have, and I had certain cases like that, that here is an application from a lifer for parole, recommended by the Parole Board, recommended by the NCCS, the crime that this applicant, for instance, raped an 8-year child, 11-year child, and a 14-year-old child. Right, and brutal. He was sentenced to life. His risk of reoffending is moderate to high. And then it is recommended. And then if you go and look, it also says he must not be able to be in touch with minors. How can you assure that? In that specific case and other cases, I rejected the recommendations from the NCCS as well as the Parole Board, and I did not approve parole. And I will keep at that. And I said to my people that if I do not approve such an application for parole, let's go to the court. Then it is on the conscience of the court if they want to say the person must receive parole. Because I don't want to see that after a year or 2 years that there's another rape of a child. Therefore, I'm very adamant about that. I will keep to that, and it is an objective criteria I used. When it comes to the Alison Botha case, I'm not going to say too much. We may go into a litigation. And that, of course, was a cancellation. It was, in terms of the legislation, within the 2 years. I said it in the media. You must first remember that we were confronted by a litigation process by the legal advisors of Alison Botha. Because their argument was, for one of it, is that there was no victim consultation in terms of consideration for parole. Now, first, I also want to say the decision to put them on parole was before I became the minister. But it is in the 2 years, as I've stated in the section of the legislation of the Act. I then looked at the case, considering the fact that we are confronted with a litigation process. And yes, I think someone asked whether I received external legal advice. Yes, I did. I think the honourable member asked that. Of course, I've asked also for external legal advice. I said once in the media that I'm looking at all the facts and proper legal advice. And on that advice, it actually said that I can cancel the parole. I don't want to go into the detail because, as I said, we still may end up in court. But when I looked at the profile, I had also very good reasons referring to the risk, as I've mentioned. The risk was a very important matter. And even if you look at the findings and what the judge has said in his sentencing, that is part of it, not all. But it was such a serious, and can I say, gruesome case that the judge said that these two people should never go on parole. And I think the Honourable Miao said some people should never go on parole. That's what the judge said. But still, you can hear what the judge said, but you can still make an objective decision. So let me be very clear about the Alison Botha case. I am prepared to go to court, and I do justify the fact that I cancelled their parole. Let me come to some other matters. I think there was a question on the parole board and which way they can interact with victims. That is part of the process. Of course, you have VOCs where they try to bring the victim, or if they still live, or the family together with the offender, and see it's a restorative justice sort of approach, forgiveness, and everything that goes with that. But in many cases, they don't do it. And in some cases, they cannot find family of the victims. But then I want proof to see what steps were taken to try to get hold of the victims. So that is how the parole board then interact and can look at the report of the victim and the offender consultations. In terms of the criteria and whether it is transparent, as I said, it is transparent. I've just told you what I consider. It's not a secret. What the individual or each individual case, the circumstances are, that's a different story. Because they are also protected, for instance, by the Poppy Act and everything like that. You cannot just give out personal details and everything in public. So it is important to understand that the process I've put forward, and that is the process, so it is transparent. And that is the criteria. The criteria we've mentioned here in the presentation, I said it's some examples. There are some other issues you can add there as well. I think if we can go, the question was, are there any political pressure on me as Minister? Chairperson, I can assure you, I'm not politically pressured. No one will politically tell me what to do. In fact, they will maybe just get the opposite response from me. I look at an objective way, on a factual way, and then I make a decision. I say again, I am prepared to go to court on each and every decision I make. And I know it will be no use to stand up in court and say, yes, but it was a political decision. I can say to the honourable members today, last year I received some messages and letters from the electorate, but I voted for the Freedom Front Plus. And I thought now that the minister will grant some parole because it's my brother or my family or whatever. They are very upset about it. But the person does not deserve and does not qualify for parole. And that's why I rejected it. I did not approve. And that is actually proof that I do not allow it to be politically pressured. In fact, there are a lot of people, you know how it works these days, the inmates, I don't know what the going rate for my telephone, my cell number at the moment, but especially on Sundays, I'll receive a lot of calls from inmates. I don't even answer it, because I cannot get involved when it comes to those sort of matters. So I am not pressured by anyone. I think, Honourable Plaatjes, that is part of the subjective. Life is life. I've dealt with that. I think as far as Alison Botha is concerned, when it comes to foreigners, that's also a question. How it works when it comes to lifers and they are foreigners. And just this weekend, I approved parole for 2 foreigners, 2 Mozambicans. But there's already a deportation order. The moment they go out on parole, then they are deported back. And from my term, from 3rd of July, I think there's about 8 to 10 foreigners. I've granted parole. I'm not talking about lifers when I talk about people, but they are when they get out of our correctional center, they are deported directly. It's mostly our neighboring countries, Mozambicans, Zimbabweans, and so on. So that is the way they are treated. Can I just say on foreigners, and I think someone, Honourable Chair, you've asked on high-level consultations and meetings, we are in a process to see, when it comes to foreigners, that we can, for instance, the foreigners that has already been sentenced, that they can be deported back to their countries. But that needs international memorandum of understandings or international agreements that you can send foreigners back to their country of origin. But at this moment, we are confronted with the fact that the Act again says that if a person is sentenced in South Africa, correctional services must see to that person. And that's why, and I have given statistics a couple of times in terms of foreigners, and it is a huge problem. Because even if you look at remand detainees, foreigners awaiting trial, where we sometimes are confronted with the fact that this person is actually illegally in our country. That is then when home affairs are coming in. They should deal with the matter and send the people back. So that is what we are doing. I think it was the Honourable Sepolko who said incarceration before 1990 Act, that was said. And he referred, I just referred to the Shabu Sheikh. In fact, Shabu Sheikh is actually not relevant because he's not alive. He was not alive. But some people, they don't read very clearly, and then they ask me now, what am I doing about the matter? They have served their sentence long ago. The same with Mr. Zuma. So it's out of our hands, and they're not lifeless. So it's not part of my problem. It was also said that, and I think you said lifers went to court. Yes, it's true. We had a couple of court cases by lifers, applications. Most of those cases was not about the fact that they did not receive approval for parole. Most of those cases was that the minister didn't take a decision. And that is part of the fact that when I became the minister, I was confronted with a backlog of 495 applications of lifers for parole. Some of them waiting more than a year, some almost 2 years, because the Act does not stipulate the time frame when the minister must take a decision. So we dealt with that, and the honourable members will remember that I've said by the 3rd of October last year, from 3rd of July, I worked on the backlog and all the new applications, and I said we are 100% up to date. And I can say to the honourable committee members now that I am still 100% up to date when it comes to the applications of lifers for parole. As I said, just this weekend, I dealt with 68 applications. So I try my best to do it at least in 30 days. In the weekend's case, I did it within a week when I received the final report from the NCCX. So I will keep up with that. And there are other cases where people thought that they can, or they have the right to receive parole. Now, we've won those cases. We have some very good cases, very clear cases, that states it very clearly to applicants that it is a privilege to receive parole. It's not a right. And that is the decision of the Minister. Thank you, Honourable Chair.
Thank you, Minister. Members, any follow-ups? Honourable Naus, Honourable Nawa. Thank you.
Thank you, Chair, and thanks for the expansive response that the Minister had given. Minister, I want to concentrate specifically on what you called the Van Vuren case, because it raises some serious concerns for me. Do I understand correctly that in terms of the Van Vuren matter, therefore, anyone who was sentenced before that case was heard automatically are entitled to be released and to have parole after 20 years, and that parole period will then be 3 years, and after that they're out of the control of the Department of Correctional Services. Now, Minister, if that is the case, it really raises some very, very serious issues with regards to what you correctly said, that one must be very concerned about the whole issue of the risk of reoffending. So here you have a process where people who may very well have a profile that they can reoffend, if my understanding is correct, automatically will get parole anyhow. And after 3 years, they're out of the correctional services system. Now, if that is the case, we are faced with a real dilemma, because then there are people who are going to be released, although they do not have the correct profile, although they do not show the necessary remorse or rehabilitation. And therefore, we can be accused as a country and as a system of releasing people that we know very well are going to reoffend and may commit again some very serious crimes. I want you to respond to that, Minister. And then, of course, Minister, I think we can, with total certainty, say that the decision that was taken to grant Janusz Wallace parole was wrong in terms of his lack of rehabilitation. But as you have explained to us, if that interpretation is correct, regardless of the fact that there was no rehabilitation, and we could have known that, it was an automated process, an automatic process of release. Now that is a miscarriage of justice. And I think we need to apply our minds very, very carefully on what can be done to change this. We, as representatives in this Parliament, when we object to such situations, have the right to change the law. And I think we as a committee, and those of us here as members of Parliament who can also table private members' bills, have to consider a serious intervention, if that is correct. And I want to have your answer to that, to stop this from being able to happen. And I still repeat again, although you say, Minister, that you think you will lose the case, I think it is a matter of correct politics and a matter of correct law and a matter of correct public perception. Even if you're going to lose the case, if you think you're going to lose the case, to still go through the process of officially revoking the parole of Janusz Wallace and making an application for him to be extradited back to South Africa. I would like the Minister's response to those two issues. Thank you, Chair.
Honourable Ngapa.
Thank you, Chair. I did not have one of my questions answered. So, Minister, I'm mindful of what you said about the Alison Botha case. I'm not going to ask you to frame it specifically that way. But more broadly, what I would like to know in terms of your power to revoke parole, do you have the power to initiate that process? The way I'm reading the legislation, it comes from either the, what is it, Correctional Services Parole Board would make a recommendation, and based on that, you must make a decision, the Act says. I don't see anywhere where it says you can take the initiative. So, yeah, can I just get clarity on how you read the law in that regard? If you do think you have that power, what section is that based on?
Thank you, Honourable Minister.
Thank you, Honourable Chair. Let me just deal with the last question on slide 12. Process for cancellation for lifers. You will see they go through, and then it says no NCCS recommendation is required. The decision of the board or the minister is subject to the PAIA, and each case is considered on its own merit. So, yes, I do have the power to make the decision. Of course, if I want to ask for some recommendations, I can do so. But it says the reasons for cancellation: non-compliance with consideration process when parole was approved, so and so, non-compliance with non-parole period set by the court. Okay, maybe that we misunderstand each other.
Oh, no. You are answering, but I have a follow-up to. May I proceed, Chair? So can I just check? Okay. What I'm saying is I think he's misinterpreting. Can I correct him so he can answer?
Okay.
This parts that you are reading there, those are not from the Act, right? I'm assuming whoever compiled your slides, so that those aren't from the Act. Which part says, because as you can see, that 75,6, when the board, before that, there's a section that speaks to when you get recommendations, you must make a decision. That's where 75,6 comes in. But all of it presupposes that you received a recommendation. So can you point me to a section of the Act, not your slides, that gives you the power to initiate?
Let me say, Honourable Chair, if you look at the slide, section 75, subsection 9, if you refer, it says the minister may cancel correctional supervision, day parole or parole as referred to in subsection 6, the above one, only if the decision to grant correctional supervision, day parole, parole was taken by the minister. So there is a precondition that the decision to grant parole must have been taken by the minister. So that is what it is. So I don't know if we misunderstand each other on the matter, but...
Sorry, my argument is that 75 is not the one that deals with lifers. I think what's been included there is not correct. So if you go directly to the Act, it's actually 78 that deals with lifers.
No, I differ with you. 79 does deal with lifers. It is with lifers. It's a process for cancellation of lifers. That is what it is. Okay. I'm coming back again to the Van Vuren case and what the Honourable Niaos has asked. The fact of the matter is that there was a constitutional court case. And let me also say, it is, when I've read it and I refer to the Van Wyk cases, it is still a matter it may be considered that we put that. It's not that they are automatically, can I say, entitled to that. But in the Valus case, it was a matter of the Constitutional Court. And it was a parole for 3 years, if I can remember. And when that has expired, it was the end of his sentence, of what he can serve in a correctional center. And that's a finding of the Constitutional Court, I say again. Ask me whether I think still, whether I think we're going to lose the case or not. I mean, and I'm very careful what I'm saying now. Mr. Niaus, and I respect honourable members from Parliament. I'm myself a member of Parliament. I'm very cautious that because of political pressure, that we must now go into this matter and is taking the taxpayers' money, if we know that there's a good chance that we may lose the case. I think from your side, yes, if you want to come forward with a private member's bill, you're most welcome. But I'm honest with you in terms of my view on the matter. I have to comply to the findings of the Constitutional Court. It's not for correctional services to start that process. Then we must go to international relations. I, for instance, and it's not only in this case, I had some previous cases when it comes to lifers with an application. I looked at the case and certain mistakes were made in the process, and I said, right, it's fine. We're not going to object to the case because it's going to cost the taxpayers money. If you go to court, we talk about, yeah, between $500,000 and $1 million at least, depending on where the process of the court process is at that stage. So my answer to you is, from correctional services, we're not going to initiate that process. If the honourable member can speak or talk to his party and see if they can talk to the Minister of Justice or the Minister of International Relations, I think he must follow that route. Thank you.
Chair,
Thank
just
you.
to clarify, please.
Sure.
Thanks. Minister, I do think you understand the seriousness of the matter. So I don't think we ought or should be in any way flippant about it. And of course, if one has a problem with the law, we as lawmakers can change them. So the fact that there is a constitutional court judgment in a particular matter, when the law changes for the future, that constitutional court will have to take into consideration the changed law. Because yes, I'm not just talking about Janusz Walusz and his particular case, important as it is, and emotional as it is for a very large part, I would say the majority of people in South Africa. And that cuts across political lines. So let's not narrowly define the issue of politics here. It's a national interest. It's a national outcry. But let me leave that. The issue is broader, as I said earlier, and it is about the release of people. And you say there's not an automatic, but it sort of happens anyhow. It's about the release of people who, in all probability, are likely to reoffend again. All probability are likely to reoffend again, because they do not show the necessary rehabilitation. So under those circumstances, if one changes the law, it can close that door. And in future, the Constitutional Court will have to be bound by the changed law. And it is in those circumstances and with that intention that I referred to the fact that I think it is necessary for a private member's bill to be brought in order to address that issue and close that door. Because I'm sure, Minister, your own statement about your concern about the risk of reoffending supports that. Thank you, Chair.
Thank you, Honourable Nehaus. I just want to indicate to members that we still have another presentation, and it is also during the plenary. It is our oversight report will serve where all of us would need to be at the plenary. That starts at 2. Just to assist in terms of the question from Member Ngaba, she asked the question in the law, where does it state that the minister can initiate? Because it's not there. It states there that the revocation can take place after A, B, and C happened from the National Correctional Services Council and all of those steps. But where does it? It never states there where can the minister initiate such a revocation on its own, if I have it correct, Member Nab.
Yep. So, Chair, I'm not going to ask a question. I'm with you that we need to move on. Can I please clarify to the Minister what I'm saying? Because I really think his team needs to look at it. When the Minister was responding to me, he referred to Section 79. I've got the Act in front of me. 79 deals with medical parole. Now, I assume you're talking about that one there, 75 subsection 9. But if you look at the top of 75, it deals with powers, functions, and duties of the Correctional Supervision and Parole Boards. So all that 9 is describing is where you and they interact, but it doesn't deal with your powers. Your powers are in Section 78. And in particular, 78.3 is where it starts with the lifers, and it starts with when you have received the recommendations. Now, again, I repeat, let me speak for myself. I'm on your side with Alison Botha. I hope you win. What I'm afraid of is if the recommendation didn't come from a parole board or whatever, you might be in trouble. So there's no need to answer me. You can just review this, have your legal team look at it. I just want you to be sure that you're relying on the correct things in taking that case forward.
Thank you. And then the last.
Chair,
Sure.
I don't want to ask a question. I just want to caution the Minister on matters that he raised, maybe as Honourable Carl is saying, becoming flippant on some of the issues. You cannot say in this public domain, Minister, that you will clear your conscience by taking something that you feel is not right and was not rightly oversight by the judges, and send it to them so that it can lie with them and your conscience being clean. So I'm just raising that we shouldn't have a minister saying that he should say, I've thoroughly processed this matter and therefore I'm taking it there. Not my conscience must be clean when I'm taking it there. And I'm really worried about that kind of approach. It's just a statement, Minister. You can take it as you take it. But I think it's important that I raise this issue and not let it go out of this meeting without raising my concern.
Thank you, Chair. I hear what the honourable member says. I said very clearly when I started that I will comply to the legislation objectively, but I do have a conscience, and each and every person has a conscience, and members of Parliament also have a conscience. And when it comes to legislation, I think, and that's my view, and I won't change it, that you must also apply your conscience when you try to approve or initiate certain legislations. I think it's a good example. It's also a matter of conscience that the Honourable Nehaus feels that there should be new legislation to deal with this matter. So I hear what the Honourable Member is saying. I respect your view, but I have my view on that. Because I said it also in my department. Correctional services are there to serve. It's service, correctional services. What does that mean? It means that we have to serve the public, the people of South Africa, and we serve them by protecting them against criminals. That's what our task is, to create a safe environment for the citizens of South Africa. And that's why I say, when I make a decision, I do ask myself, because I received a recommendation from the Parole Board as well as the NCCS to say this person can go on parole. But the risk of reoffending is moderate to high. And then I say to myself, so because there are two recommendations, I must approve. But what then if that person reoffend again and rape another child? And that is where conscience comes in. Of course, I want to prevent it, but the objective criteria of that is the fact that the risk is moderate to high. Let me say I think it's a technical issue. Of course, the powers are from Section 78, but when it comes to the cancellation, and that's the way I understood it, the cancellation of lifers, then we talk about Section 79, because yes, that's where the powers are. But then 75, subsection 9 says it quite clearly. When it comes to the cancellation, it is the minister. But I think it's a technical matter that we have. Can I lastly, Honourable Chair, and I say again, it's from vacancies, it's not automatically, and maybe I have expressed my incorrectly there, they then can be considered. I was asked for statistics, someone asked me. Now, since I became the minister on the 3rd of July till the 6th of May this year, I can say the following. We received, in terms of the Van Wyk cases, parole was granted in 21 cases, day parole in 1, and parole and deportation was 3, and rejected for, asked for further profile was 662. That gives a total of 687. When it comes to lifers, in terms of the Act, none. There was only 2, and I did not approve them. In total, I can say, if you add all the cases, Van Wyk, Parla, Van Vuren cases, and so on, I granted 26 paroles, 3 day paroles, 4 parole and deportation, and further profiles 955, it gives 988. So those are the statistics. But I think there is a question in the National Assembly specifically on these statistics. It is all there. I can even give you how many parole revocations, approved 36, withdrawals, cancellations, and so medical parole, reinstatements 10, and so forth. So the statistics are there, but I'm not going to take the time further. There is a question, and we will have all the statistics there. Thank you, Honourable Chair.
Thank you, Minister, for giving us clarity on this. Honourable members, if needs be, we'll further investigate some issues as we go forward. But thank you very much. If we can move to item 2, which is for the department in terms of the review or the overall of the parole system. Now, before I give over to you, Madam, there's a very long, I think it's 56 pages presentation, and there's a lot of statistics in terms of vacancies and in all the different centres. So if we can skip that, and you just give us a gist of that, but let's keep to the core of the matter at hand in terms of where are you at with this process, so what's the steps forward to, so that, because I'm very mindful of the time, especially because our committee is expected to attend the plenary in person, that's starting at 2. So thank you very much, Madam Acting National Commissioner. You have the floor. Thank you very much.
Thank you very much, Acting Chairperson, and thank you, Honourable Minister, thank you, Honourable Deputy Minister, and let me also greet all the honorable members and also colleagues. I am going to first introduce the team that I am with. At the back, I do have CDC, that is Chief Deputy Commissioner Human Resources, that is May Linda Bond. I also have DC Social Reintegration, Ms. Mtetwa. On my right here, I have a director from Parliamentary Liaison, that is Director Mabunda. I also have Director Singabako Numalo from Communications. I also have Acting Director Pre-Release Resettlement, that is Ms. Moremi. She's just next to Director Singabako. I also have the Acting Director Administration in the Office of the National Commissioner, that is Ms. Tembi Kwamanda. Thank you very much, Chairperson. I will be taking you through the presentation on the progress of overhauling of the parole system. So there are two presentations in one. So I'll take the first part, and the second part will be on capacitation of Correctional Services Parole Board and Community Corrections. That will be presented by CDC Human Resources. That's where most of the statistics is, and she will focus, as we have indicated, Chairperson, she won't go through each slide. And we also have the last presentation from DC Social Reintegration that's more in line with the issues of revocation from Community Corrections. So those will be the three presentations that the department will be doing. In terms of the process of overhauling the system, there's a table of contents there. I'll indicate the purpose, the background of the parole system in South Africa, stakeholder consultations on overhauling the parole system, the identified challenges and proposals for review, the status and way forward, and will also indicate recommendations and conclusion. And the last bullet, as I've already indicated, that is on the capacitation of correctional services, parole boards and community corrections. That's where it talks about CSPB's vacancies. The main purpose is just to provide the portfolio committee with progress on the overhauling of the parole system, including filling of vacancies in both parole boards and community corrections. Chairperson, with regard to legislative mandates, I'm not going to go deep into that. We do have Correctional Services Act, we do have Criminal Procedure Act, we do have white paper on corrections that is guiding the implementation of the parole system in South Africa. So we have just given a bit of a background in terms of where we are coming from with regard to parole system in South Africa. As we are all aware that in 1993, the department introduced amended legislation by establishing a number of decentralized parole boards with the primary objective of considering the placement on parole or correctional supervision of sentenced offenders. The recommendations were made by the boards. That they were submitted to the minister or the commissioner for a decision according to various levels of delegation. So the previous board, it was consisting of departmental officials. So all the members of the parole board previously, we had the chairperson who was the deputy director, the vice chairperson who was at the level of assistant director, we had secretary, we also had member of the institutional committee, and any person co-opted to provide an input. So on the member of the institutional committee, previously it was called institutional committee, but now is the case management committee. So that was the composition of the previous board. Then during implementation of the parole system, as the department, we received various concerns, or should rather criticisms, that it was not transparent in its administration, especially that the board was mainly managed by officials within the department. So those criticisms were raised by the public, and they were led by the minister. They were submitted to the minister, and the minister requested the National Advisory Council to review the release policy during 1994 based on those criticisms that were placed at the Department of Correctional Services. So minister requested the National Advisory Council to look at the new parole dispensation, which was in line with the Correctional Services Act. Then in the new legislation, in the Correctional Services Act 111 of 1998, the composition was reviewed, and it now consists of the chairperson, who is a community member, the vice chairperson, also a community member. The only person who is an official from the department is the secretary, who is a DCS representative. And we also have 2 community members, and we also, the legislation indicates that we also need to co-opt members of the South African Police Services who must form part of the Parole Board. So the current CSPB, that is the Correctional Supervision Parole Board, that was introduced with the legislation in 1998, the main function of this CSPB was more to ensure that they are independent, and they are also responsible for considering an approval or disapproval of placement of offenders. They also assess the risk level that the offender might pose. They also analyze the reports from professionals and also grant special remission of sentences to offenders. And they make recommendations to the minister regarding offenders sentenced to life imprisonment. So those are the basic functions of the current parole system. And currently we do have 52 CSPBs, that is Correctional Supervision and Parole Boards. So that 52 is in each region. Free State and Northern Cape, we have 7 parole boards. Eastern Cape, we have 8. Gauteng Province, 11. KZN, 8. Western Cape, 10. And LMN, 8. So all in all, we do have a 52 Correctional Supervision and Parole Board established in line with the Correctional Services Act. So in terms of this legislation, members from the community and other role players such as Department of Justice and SAPS were for the first time included in the parole decision making, as I've indicated in the previous slide that the members of SAPS, they now form part of the CSPB. Furthermore, it also made provision of victims of crime and their relatives to make written submission to the Correctional Supervision and Parole Board or to attend meetings of the board. And in 2015, the then Minister of Justice and Correctional Services informed Cabinet that he would be making a submission on the proposed restructuring of the parole system. So this was made in response to those criticisms that were made in terms of the parole system. And there were quite a number of litigations due to inefficiencies which led to delays in processing of parole profile reports. While still on the background, it was recognized that the current parole system, which has been introduced in 2004, is more than 2 decades and needed to be reviewed. So in 2016, the Minister of Justice appointed a task team to drive the re-engineering of the parole system, which was subsequently announced in the budget vote speech. And the team consisted of officials from the department. So the minister appointed officials from the department to ensure that they review the parole system. So in 2017, the task team developed a draft position paper titled A Revised Parole System for South Africa. So that was the first step towards the review of the existing legislative and policy regime, as well as the practices and administrative tools for their implementation. So after that, a draft position paper was developed. We then had various stakeholder consultations on overhauling the parole system. So we utilized that draft position paper as a basis for discussion. So role players were invited and other interested parties to make their inputs. We had a roundtable discussion on the position paper, which was hosted by the NCCS. That session was held on the 28th to the 29th of May in 2018. Apologies. And the session was also attended by the then Minister, the Deputy Minister, JICS, NCCS, and representative from branches, incarceration and corrections, community corrections. We also had external stakeholders such as Sonke Gender Justice, African Criminal Reform, NICRO, and Vets Justice Project, amongst others. We also have academics who were part of the session. So the NCCS and JICS have consulted the discussion document and they have provided their inputs. So they've submitted their recommendations, which have been taken into consideration in terms of the draft position paper. So the draft position paper, as I've indicated, the task team revised the entire parole system from admission to placement on parole in the system of community corrections. So they did not only look at one specific section, they've looked at the entire process from admission up until placement. The reason being that we wanted to provide lasting solutions pertaining to the structure and functions of parole boards and related matters. They've also looked in terms of the criticisms that we received from public, hence the task team looked at the entire system. So after the task team have developed that draft position paper, there were some of the challenges that were identified with the current parole system, and some of the challenges identified, some were administrative in nature, some needed possible amendment of some provisions of the Correctional Services Act and the Criminal Procedure Act. So in terms of those challenges that were administrative in nature, we have addressed those challenges. For example, as a department, we then developed a decision-making tool that is currently being used by the CSPB and also the case management committees. The issue of compulsory restorative justice for all sentenced offenders were also taken into consideration, that sentenced offenders must go through the victim-offender dialogue and also victim-offender mediation, that is the restorative justice program. We have also developed the risk and relapse probability tool that both committees are now making use of that tool. So those are just some of the key administrative issues that were identified, and during the process we had to ensure that we start implementing those ones. Then there are other identified challenges and also proposals for review that is included in the draft position paper. For example, the first one being the system of parole boards and parole review mechanism. One of the challenge that was identified with regard to that is the inconsistencies in decision-making by different parole boards as well as review mechanisms. There's also the issue of roving CSPBs. As we have indicated that we do have 52 CSPBs, so those CSPBs, they do attend to other management areas where there are no correctional supervision and parole boards. So in terms of the proposed solution that have been identified, is that there should be a 3-tier system that needs to be established. So the task team proposed that there should be the CSPB at correctional center level, at management area level, at regional level, and also at national level. So those are the different levels that they propose, that we should have management area, CSPB, regional CSPB, and national CSPB. And they have proposed that the functions of those CSPBs will be outlined. They have indicated the decision-making authorities in terms of those levels. For example, with regard to the National Parole Board, they've indicated that they've proposed that the chairperson and the vice chairperson should have knowledge and experience of the correctional or judicial system and knowledge in human behavioral sciences. And they should also focus on those offenders that their sentences, the minimum detention period is 25 years. Then the provincial will determine their sentence will be those that are more than 30 years. So they've indicated in that document, it's quite a huge document, but they've proposed they've proposed in terms of the decisions that needs to be taken at each level, from management area, provincial, and national level. Then the other issue in terms of the challenge that has been identified was the dedicated structure for implementation of the correctional sentence plan. So currently we had a challenge in terms of a financed position of case assessment officials, case intervention officials, criminologists, and also inadequate appointed professionals to render rehabilitative interventions. So some of these officials, like the case intervention officials, we are utilizing our officials on an ad hoc basis. Hence, it was proposed that we need a dedicated structure. But as the department, that process is underway. We already have a macro structure that has been approved, and we are currently working on the micro organizational structure, which will cater for the issues of correctional intervention officials and also case assessment officials, to ensure that those officials do not do such tasks on an ad hoc basis. Also, the issue of criminologists, we are also working on that. We currently have only one criminologist in Western Cape, but we are reviewing the structure to ensure that we have criminologists in all the regions. So we are going to start doing it in phases, whereby we'll have one criminologist in each region, and thereby we go down the level in terms of management areas and correctional centers. So we have already started with that process. The other challenge is restorative justice in correctional services. As I've indicated, that with regard to this review, we ensured that the restorative justice program is implemented and is compulsory to all sentenced offenders. So we were doing restorative justice as, like, we only had a deputy director responsible for restorative justice program. But with the review of the structure, we now have a directorate specifically responsible for this restorative justice program, to ensure that all the victim offender mediation, victim offender dialogue is being catered for. The other issue is also in terms, whilst we are working on this restorative justice program, we also have social auxiliary workers that are assisting us in terms of tracing victims. So that structure of social auxiliary workers, we are utilizing we are using CARA funding to appoint the social auxiliary workers that are assisting us in terms of tracing victims. Other issues, there are quite a number of issues that have been raised, like roving parole boards, high caseload on offenders, also the impact of sentences on lifers. So those challenges, as soon as the review is being approved, then we will be in a position to implement those proposals that have been made in the discussion document. So one of the critical ones is in terms of the roving parole board. They propose that offenders should only appear at the CMC, that is the Case Management Committee. So hence I've indicated that issues that have been raised in that document, we are still working on those issues, and as soon as they are consulted and the executive authority has taken the decision, then it will be implemented. Then in terms of the status and way forward, is that in July 2023, the status of the review of the parole system was presented to the JCPS structure, that is the DGs and ministers, and it was recommended that the draft position paper should be tabled at Cabinet as work in progress, while the department is still going to finalize the implementation of those proposals made. But however, the matter was not tabled due to the commencement of the 7th administration. So currently the department is engaging internally with the executive authority prior finalization of the revised parole system, and also in preparation for tabling at Cabinet. So as soon as all the issues have been ironed out with the executive authority, then the process will continue in terms of overhauling the parole system. In concluding this first part of the presentation, we would like the Portfolio Committee to note the progress on the overhauling of the parole system, which will require some of the possible amendments of some of the sections of the Correctional Services Act and also the Criminal Procedure Act. So in terms of the Criminal Procedure Act, both processes we have commenced in terms of reviewing them. Criminal Procedure Act, we have received an invitation from the Department of Justice that we need to provide our inputs and comments in terms of reviewing the Criminal Procedure Act. So we will be working on that and providing our inputs with regard to reviewing the Criminal Procedure Act. So from our side, with regard to the process of overhauling, that is where we are in terms of the progress that we are currently engaging with the executive authority internally. And as soon as we have agreed on those proposals, the ones that are going to be implemented, then executive authority will give a way forward in terms of that. Thank you very much, Chairperson. I'll hand over to CDC Human Resources to take us through capacitation of correctional supervision and parole boards, medical parole advisory board, and also NCCS and community corrections. Thank you, Chair. Thank you, Minister and DM.
Thank you. Minister?
Thank you, Chair. It's your decision. And you've referred, if you look from slide number 13, actually from slide number 15, up to slide number, I think it's 53, it's all about statistics. So if you agree with that, we can skip that, all the statistics. And then we can just go to slide 54, and I think the last one is 55.
Yes, I would like that very much, because we need to be mindful of time. And then after the conclusion of all the presentations, I would like to give you and the Deputy Minister also a chance to add anything that you feel that should be added before we go over to questions from members. Thank you.
Thank you, Chairperson, Honourable Members, Minister, Deputy Minister, Acting National Commissioner and colleagues. I'm going to take you through this portion regarding the capacitation for the parole system as well as community corrections. In terms of, as you've indicated, the statistics, I'm going to skip, but I just think I need to give a summary of the vacancies. In terms of the chairpersons, we have 17 posts vacant against 35 filled, and then vice chairperson 22 are vacant and 30 are filled, and community members we have 62 vacant and 42 filled. Overall, what we can report is that we have advertised all the vacancies of chairpersons, vice chairpersons, and community members in the previous financial year, which was September last year. And when we advertised the posts, we advertised not only the ones that were vacant at the time, but the ones that were going to become vacant in the next 6 months. So the regions are currently busy with the review or with the filling of those positions and are at various stages of the filling positions. Most of them are busy with interviews, some are busy with shortlisting, but the process is at an advanced stage. And each stage of the process, because it is a ministerial process of approval for the appointments, comes to the minister for consideration. In terms of the review of the parole board contracts, the department has had to defend a number of disputes or cases in various courts, as the committee is aware, owing to conflicting contracts of the chairperson and vice chairperson of the Correctional Services Parole Board. And so in an effort to put an end to this problem, the department then had a number of engagements where we then obtained a legal opinion on how the matter should be dealt with and resolved. The challenge that we are having with these legal opinions that we obtain is all of them are contradictory. Sometimes it will be that they should be independent contractors, sometimes it's that they should be employees, and but the final legal opinion that was obtained culminated in the drafting of a revised contract. However, in implementing this contract, we realized that it presents a number of implementation implementation challenges, because in the contract itself, there are contractual provisions that firstly are in conflict with the spirit of the Correctional Services Act, and also contradictory clauses in the proposed contract where there is a proposal of conditions of service that the department wants to introduce, which contradicts their nature of appointment. So the service delivery requirements also contradicts their current conditions of service, because we are expecting them to be in service for a number of hours where, in terms of the Labour Relations Act, they are then should be considered as employees, but then the Correctional Services Act expressly indicates that they are not employees, and that the only employee on the board is actually the secretary that is appointed by the National Commissioner. So those are the challenges that we are facing now. So we are interrogating the contract further. If you can go to the next slide. We are interrogating the contract further in order for us to then come up with a contract that balances both their independence as well as the service delivery requirements and compliance with the current employment legislation. Can proceed. In terms of the medical advisory parole boards, that is the status. We have received the applications for an additional 5 positions because we realize some of the provinces do not have medical advisory parole board members. So that process is underway to fill those additional provincial positions. Proceed. In terms of the NCCS, all the posts are filled except for 1 member of the South African Police Service and the judge or vice chairperson, where we are in the process of consulting with the Chief Justice to appoint a 3rd judge, and then also with the National Commissioner of SAPS in order to nominate a representative after the retirement of the member, that's Brigadier Ngwen. Let's proceed. In terms of community corrections, we are at a 14% vacancy rate at the moment, and this is more or less reflective of the general vacancy rate in the department, and we are in the process of filling all positions in terms of our recruitment plan for 2025-26, and before the end of May, we will be advertising all community corrections vacancies, and some of them were already advertised in terms of the professionals that support the community corrections process in April of this year. So, as part of the enhancement of the structure for the repositioning of community corrections, 2,000 of the 6,192 correctional officers that will qualify for appointment after the completion of the Correctional Services learnership over the MTEF, 2,000 of those are going to be allocated to community corrections. And the allocation will be based on the caseload and the geographical location of the various community corrections officers. In 2024-25, despite the fact that we had stringent financial constraints, we did fill 47 community corrections positions. And the community corrections posts, as I indicated, are included in the recruitment plan that we've developed for the filling of scarce and critical vacancies in 25-26. Thank you, Chairperson, and thank you, Minister and Deputy Minister and Honourable Members.
Is there one more?
Thank you, Chairperson. The next one I was just requesting the minister that we can consider the presentation read because the chunk of the presentation is on revocation, which minister has already presented. So that was the last presentation. Even if they can just put it there, you can see all the table of contents. It includes all what the minister has already presented.
Yes, no, I agree. Thank you very much. Then, Minister, Deputy Minister, anything from your side?
Good afternoon, Chair, Acting Chair, and good afternoon to the Minister, members of the portfolio, the Acting NC and the team and the entire management that is here. Chair, let me start by apologizing. I was caught up, SAA drama, the delays. My apologies, I had to bear the brunt of arriving a few minutes later while you have started. But I think the presentation has covered a lot of issues which also the minister has dealt with, but also to say the review, we must allow the process to unfold. Like it has been reported that he has gone to the cluster and the minister will come back and table it, then it comes back to us so that we partake in those reviews so that it assists us. But mainly the issue has been covered. Also, the intake that we were reported in slide 54 to say there's a new intake, and that will also assist because correctional services is facing a challenge of those that are exiting the system. And we must prepare a new intake because we must really work towards having more boots at the level of operations. Hence, you've seen also in the presentation, it gives you specifics to say at the level of management areas, it's where we're focusing other than focusing nationally so that we fill those vacancies. But with the budget constraint, but we're trying very hard as a department to make sure that in our management areas, there are boots on the floor to make sure that community corrections and supervision, it happens. Thank you very much.
Thank you. Minister, you?
Thank you, Chair. Now, from my side, I just want to say that I want to emphasize it to the Portfolio Committee that we have really serious budget constraints in correctional services. And I want to say again, over the last, say, 5 or 6 years or so, the budget was cut with about 11.7 billion. It's got an enormous effect on personnel. Let me say, for instance, I've visited one of the centres, Westville, in KZN, where 4 officials have to oversee 660 inmates. So it's really a problem. We need new technology and everything like that. But as that may be, let's see what comes forward after the new process. But I also want to say that you will see since 2015, there was a process started to try to come up with some revised parole system. Well, we're talking about 10 years from now, or before we 25 now. Now, I don't know which of the honourable members were on the Portfolio Committee for that period. I don't know really what happened. You've had a presentation of all the steps and everything. I, as Minister, don't want to see that we're going to take another 10 years. In fact, I would like to see within the next 2 years that we finalize this matter. We're also planning, for instance, a summit where we can engage stakeholders. You have saw some of the stakeholders already involved in the previous. But we must not try to invent the wheel from the start. We can take the good from the present system and see how we can improve of that. And of course, the members and the Portfolio Committee is going to play a vital role in that process. So from my side and from the Ministry and the Department side, we will push this reform of the parole system. Thank you.
Thank you, Minister. Members, over to you, if I can have hands. Okay, thank you. Honorable Daniels, Honorable Naba, Honorable Nehaus, and Honorable Muela and Sekopo. In that order, thank you.
Thank you so much, Chairperson. I'll be very brief. I welcome the presentation. And let me stick to what I say I'm going to be brief. I just want to encourage the Honourable Minister, the Honourable Deputy Minister, to find time to sit together and talk about the filling of these vacancies. Because from a not so good experience within the Department of Correctional Services, we found that people applied with hope and expectations, only to find that those who applied didn't meet criteria. And I don't want the same thing to play on our screens again. We can't have a repeat of such things, whereby those who applied did not meet the criteria, and then the criteria got changed to suit those who didn't qualify. And I think we must learn from that, because if it is then the case whereby, which is my suspicions indeed, that those who didn't qualify were already told, don't worry, you'll get the job. So now a plan had to be made because the criteria was only changed after they failed. If it is indeed that it's for some reason that some people feel that this people and that people and this one and that one must come in, surely, considering our high unemployment rate in this country, if those who applied failed, then reach out to others across the country to apply. Because surely when you shortlisted, there are many who would have qualified, who would have met the criteria, who didn't make the shortlist. And now them too are out of contention for job opportunities because for having to consider those who failed to qualify and therefore tweaking the criteria to accommodate them. That cannot be right. What hope are we giving to our unemployed youth in the main when it comes to job opportunities? When the truth, the uncomfortable truth of the matter is that many people on this course that was pointed out just now don't belong there. They don't belong there at all because they failed the criteria. And I asked the question specifically, did you change the criteria after they failed or before or during the No, we changed it after they failed. That's wrong at all levels, at all fronts. And it's an injustice to all of those others who are applying for positions. And if that is the way we're going to do things, then I'm afraid we'll have to look across the board at all different portfolios and departments and directorates, because then it's probably standard practice to do so. We are here to give hope to South Africa. We are here to give hope to the unemployed in the main. Because the greatest gift you can give anybody in today's day and age is a job opportunity, and particularly fairly processed so. So I want to encourage the Minister and the Deputy Minister to find time, drink tea together and discuss these things so that we can get the answers. And lastly, I've also asked, and I see the digits there, quite high digits there, employed. I've also asked, bring us the names of the people who failed so that one can have proper oversight as to who are the ones that was brought in through the back door. So we must not waste each other's times, and we must not disappoint the hopeful ones who apply for job opportunities when this is the way we do things, considering the positions that we have in this country, which is to be fair, which is to treat everybody equal and create opportunities for all. But this doesn't speak to that justice. It speaks to injustice. I thank you, Chairperson.
Thank you, Chair. So I was happy to hear the Minister point out that we can't have this review process taking another 10 years. It's already been 10 years. And Minister, you said you would like to see it happen within 2 years. Can you commit to that? Have you sat as a team, mapped out the timeline of what you want to see? What assurance do we have that this term is not going to end with this thing in limbo again? And the reason that it's important is that there are weaknesses and gaping holes that are being taken advantage of. Earlier on, the issue of litigation around parole was mentioned. I would like to take this opportunity to tell you about Miss Queen Mabunda. She is in the Eastern Cape. She's in legal services. I believe she's written to you this week complaining about collusion between the department and the state attorney's office and various lawyers who are taking advantage of the parole system to initiate litigation as a strategy for extracting money. Now, to my understanding, this is a systemic problem, and that is one of the gaps that you need to plug so people can stop siphoning money from the department through this litigation, forever litigation on parole. Moreover, I understand that it's now going to become a special project on its own. Like, is that how much money it's costing us to endlessly litigate parole? And also, what are you guys doing to protect a whistleblower who's trying to bring this abuse to your attention? We cannot have parole, which is supposed to be a system about giving people a second chance in society, now becoming a moneymaker for corrupt elements within the department. The other thing I'd like to understand, you mentioned that there's a budget issue, and I get that. Can you honestly say, Ms. Bond, I think you're in charge of human resources, is it really about the money? Why do we have so many vacancies? I genuinely don't understand. Is there no standard operating process for, okay, when you know a contract is going to expire within a year, you start advertising a year from then. And if the process indeed takes longer than a year to fill a vacancy, then advertise before that, maybe 18 months, maybe 2 years, I don't know. What is the standard operating process? Why is this always the case? Can you genuinely look us in the eye and say it's just money? Or is there a failure in the department?
Honourable Nias.
Thank you, Honourable Chair. Chair, the whole issue of parole is the process of managing the whole criminal justice system. Because what we are dealing with here is providing a second opportunity to someone who has been sentenced and who has received a certain sentence. Now, this intervention is a very, very sensitive one, because it has to be balanced between, on the one hand, the need for justice and for retribution, which is a need that society has and it has to be addressed. And on the other hand, dealing with the issue of not sniffing out hope for someone who has been sentenced. Now, the only way this can successfully be achieved is by having parole boards that are representative of the community. And that's why this whole review process is so important, because we need to get greater representation. And I understand that the decentralized parole boards has been an attempt to achieve that and to actually have local community input and involvement. But it has also led to an increase and a proliferation of litigation. Because the concern around decentralized and a proliferation of parole boards is that there is an application of parole that is not necessarily universal. And therefore, conditions come into play that sometimes could be interpreted by the community or by the person who is hoping for parole as unfair, or on the other hand, as not being on a level of general application that allows fairness for everyone. These are critical issues, and the whole process of reviewing of the parole system has to address these. Because one of my biggest concerns is the amount of litigation that there is around parole, and the costs that it also incurs for the Department of Correctional Services. Chair, the other issue that concerns me is the large number of vacancies that we have within these parole boards. We didn't go through the statistics, and I understand why. But there are far too many vacancies that ought to have been filled. And I was happy to hear that there is an ongoing process to try to achieve that. I just want to express the hope that that process is fair and that process is not going to be influenced by patronage. The Department of Correctional Services, like many other departments in our government, have a problem of patronage. It is something which has become a scourge of our government in general. And we need to find ways of addressing it. Chair, I understand the pressure that there is in terms of people who would like to get these positions. Because I appreciate the serious problem that we have of unemployment in South Africa. But I also think the issue of unemployment in our country is actually creating a situation that eats away at the core of what the whole parole system should be. Parole system, as I said at the beginning, is there to do that intervention. And in many countries, positions on parole boards are not seen as the only opportunity for employment for those people who get the positions on parole. The problem that we are faced with in South Africa because of the very high levels of unemployment is that it's taken on a different character. I honestly would have loved to see a situation where positions on parole boards are not the only source of income for those who get those positions. Because I think that sense of desperation influences the pressure that there is to fill those positions, also influences the problem of patronage, and influences, in conjunction with that issue of patronage, also the deployment of people into those positions who are not qualified to do so. So we need to find a way of dealing with that in order to avoid parole being seen simply as an employment opportunity. It is a service to the community, and it is a critical service. because it works on that interface between the issue of hope for a prisoner, but on the other hand, also the issue of justice and retribution. So I'm glad that the Minister said that this situation shouldn't prolong itself for 10 years and that we need to find solutions within the next 2 years. But then some of these issues that I've raised, I think, have to be reflected in that solution. Thank you.
Thank you, Honourable Nias. Honourable Skopo.
Thank you, Chair. Chair, I just wanted to check the criteria used. It looks like the department is very affectionate to employ retired people into these boards. I'm not sure whether are you trying to save them their pension and give them new salary and not look at using this employment or this opportunity also to attend to issues of unemployment, especially of young people in the space. Chair, I also want to check because I know in the last report on the parole board, there was mention of some of the vacancies are coming now for 3 to 5 years in these boards, chairpersons, deputy chairperson in the Eastern Cape and so forth. And I'm not sure if the minister raised the issue of cut-off budget, whether are you saying, because these are funded posts that we're talking about, are you redirecting this funded post money to attend to other issues, the fact that you can't fill these vacancies, or what could have been the case? I also wanted to check because CDC Bond was raising the issue of contracts and whether as the employees, I know some time ago, some parole boards wanted to meet the committee and we were engaging on it. Whether, because my take would have been, if they are board members, they are independent contractors. So are you considering them as employees? And I wanted to establish that, are they allowed, especially the chair and the deputy chair, are they allowed to do other things that would give them remuneration outside of being chair and deputy chair of the board? Because if you don't allow them, you are then creating space that indeed you are controlling their movement, and in terms of the labor law, then they are employees indeed. Thank you, Chair.
Thank you, Honourable Sekopo. From my side, only a couple of things. I would like to know what are the reasons the shortlisting was not done in KZN.
Order, Chair.
You, sorry.
Honourable Muela was the last.
My apologies, I didn't write it down. Honourable Muela.
Thank you very much, Chair, and greetings to the Minister, the DM, the DCS officials, and everyone in the meeting. I think let me also acknowledge the presentation from the DCS and also the previous presentation by the Minister. I think it has covered a couple of number of issues that I wanted to allude on. However, I want to seek clarity on some number of issues which were raised in the presentation. The first one will be what is the approach to wrongfully conviction and how much impact do they have on the parole system? The practice of compelling parole candidates to show remorse even when the law does not demand it is disturbing for those wrongful convicted. Then the other question will be remuneration for Correctional Service Board, is it sufficient? Is it not a reason for the high turnover and lack of commitment from people serving in these parole boards? In terms of Section 77, 1 of the Criminal Systems Act provides that if a potential parolee disagrees with a parole decision taken by the board, they may apply for a review. Do we receive applications for review? Who assists the inmates with the appeal, and what has been the success rates of appeals received in reasons thereof? What was the consideration behind leaving the formation of parole boards to members of the community instead of skilled individuals in the fields of law, criminology, social work, when there are thousands of unemployed graduates? We look at quality output versus work experience. What is the number of backlog of parole applications across the province? A board can only sit so many times in a year. What is the plan to address the backlog versus new applications without unreasonably delaying those eligible for parole? So in terms of the numbers which the minister have presented here, in terms of those that were brought into his office to look into either to grant or reject, the minister indicated that he granted, since he set into office, he granted only 21 cases and rejected close to 660 something cases, which to me is a concern with regard to the capacity of those who will be processing these cases, to a point where the number of who are rejected are so severe. So I will want to understand, in terms of those who were rejected, since you get into office, Minister, how many have appealed these decisions of the rejection of the cases which you dealt with until to date? And what led to this number of rejects vis-a-vis only 21 granted in that particular matter? Thank you very much, Chair.
Thank you, Honourable Mwela. Again, my apologies for not recognizing you when I should have. So let me start again. Only a couple of things from my side. What are the reasons for that shortlisting was not done in KZN 8 months after posts were advertised on the parole boards? Then, in terms of the review, we all know that part of the matrix of the effectiveness of a parole and parole board would be the margin of recidivism in terms of those that were granted parole. Now, I've got statistics that I'm not going to repeat here. I'm very sure that all of you are acutely aware of it. But the amount or the percentage of parolees that's released and re-offend heinous crimes surely indicates that there is something very, very seriously wrong in the application of our parole system. The composition of the parole boards and the way that members of parole boards see themselves as employees of the Department of Correctional Services, whereas it is very important and there's a very good reason for parole boards operating as independent from the Department of Correctional Services. And I know that it was mentioned that there's court cases ongoing in terms of labor legislation, which is a problem in itself, which indicates that there's serious shortcomings here. Wouldn't it be better if parole boards are taken out of correctional services from the department in its entirety, and it goes under the ministry, so that it is, because the minister appoints members of the parole board, and their remuneration and everything should come from a totally away from the department, from the ministry side, so that there's no way that anyone can misconstrue that they are now officials of the Department of Correctional Services, bar the secretary, which by law should be a member of the department. Because as I said, Honourable Sekopov mentioned it, that we had engagement with parole board members. I mean, they talk about things like overtime pay, danger pay, performance bonuses, and, you know, if contracts are not renewed, they are angry and say, you know, you're taking food off the table for my children and stuff. But surely we can't use parole boards to address unemployment in South Africa. Parole boards fulfill a very important and very specific role. And it is not for everyone to sit on a parole board. You must have certain knowledge and a certain background and a certain type of personality to be able to sit on that parole board. It's not for everyone. We need to be very clear on that. And it's not a job just, well, I don't have anything to do. Maybe I can be a member of a parole board. Surely then recidivism will go the wrong direction all over again. We cannot deal with this nilly-willy. If we look at the current system as it is, it proves to be complex and unnecessarily confusing. I think the objective of amending a system would be to, and all the legislation associated with that should be to simplify the process in its entirety for all parties involved. Its consistent application by parole board members should be dedicated by prescripts, you know, strict prescripts of what should be considered during hearings and what should not. The Department of Correctional Services parole policy should also be a public document, I think, that could act as a guide not only for parole board members but also for inmates, so that they know and they can make a calculation. This is how long I should serve. This is the criteria I need to adhere to if I want to be released on parole. These are the programs that I should finish. Then it's open and everybody knows, and it's not a guess. He says, she says, because all of these members receive phone calls from members of the public. Oh, my son is in jail. He's been sitting there for so many days, so many years now. When is he coming out of parole? Because people don't know. And if it's a public document that everybody has access to, everybody would know. And it should guide everyone also inside of the system to enhance their chances to be granted parole. I think it will make life much easier, because the way that I see it from the presentation, I think it's complicating a already complicated system now. Now you have 3 tiers. And so how long is it going to take to go through all of those processes? Because everybody's busy and you fall behind. And people get irritated inside the system because in their minds, because of a lack of knowledge, they think I should have been able to go out on parole a year and a half or 2 years ago, and then you start experiencing problems. So the objective should be simplify the system and make it the same everywhere, so that people know this is what we expect and this is what's going to happen. Thank you very much.
Thank you, Chair. Let me start by saying that I agree with most of what has been said when we talk about the parole system, and that is actually emphasizing the need for reform. I cannot differ from many of the allegations made. We must just remember that the parole boards, 52 of them, I think there was appointed 24, am I correct, for 3 years, so 24, yeah, just before my time. So they are there for 3 years. So when there's a vacancy, we can look at how we're going to fill in that post. And I'm a bit disturbed to hear about changing of criteria. I would like to have answers from my department, because it's not acceptable. And I hear what the honourable member is saying. A criteria is there for a reason. and you have to comply with that criteria. Whether you like the criteria or not, it doesn't matter. You've asked a question on the reason for not shortlisting KZN. I'm not aware of that. But the department can answer those questions. Overall, okay, let me just say to the honourable member who referred to how many I approved, must just remember that we're only talking about lifers. I only deal with lifers, not the other parolees. Yeah, but on the lifers, the reason why, I think when we dealt with the issue, I extensively said why and what my criteria is. I can't make a presentation of each and every case, but in broad, those are my principles when I have to make a decision, as I said. So that is that. The number of backlog, I think I'm going to ask, let me just quickly look here. Yes, I agree with most of the remarks. Right. It is a problem because what I also find, and it's not a general sort of thing, but I did pick up that at some parole boards that it is a matter that we have overcrowding, so we must get the people out on parole. For me, that is not a good reason to say just because we have an overcrowding now we must approve parole. There's a criteria where there should be a decision made whether a person can go on parole or not. And we must stay with that. I think what is important is that we will have to look at benchmarking with some other countries. You said that maybe not part of the department. I will welcome that because it's more independent. And there are some countries where it is actually part of the Department of Justice, appointed also with competent people, and the decision is actually final. I'm certain it depends on a criteria. So I think those are the important matters we will have to look at. I also see, can I commit myself for 2 years? All I can say that we already had a meeting, a technical meeting, and we will come forward with a time frame. Unfortunately, we are also dependent on some other departments. It's like, I can also say to the committee, there is a process from the Justice Department in reviewing the Criminal Procedures Act, which I welcome, because it has the direct impact on us. But on this specific matter, because if I commit myself, I do believe then I must keep to that commitment, like I've committed myself to the backlog of the parolees. So we will come forward, Honourable Member, with a time frame, and that is my honest answer on that one. Thank you. Maybe I can give the department an opportunity to answer on the specific questions. Thank you, Mr. Chairperson.
Thank you very much, Chairperson. Thank you very much, Honourable Minister. So in terms of the questions and comments, we've taken note of the comments, especially in terms of reviewing the parole system. So most of the honourable members gave us inputs in terms of how parole system should be reviewed. So we will look into that. But the issues of a changing of criteria, I will request the CDC HR to indicate how the criteria was changed, especially for learnership. I think it was more on the learnership that the honourable member is referring to. The other issue in terms of the composition of the parole boards, as we have indicated that in terms of the proposal, we have indicated the qualifications that are now going to be considered in terms of appointing the parole board members, like for the chairperson, what would be the requirement for the vice chairperson. So we have indicated that in terms of the qualifications required for all those members who will be participating in the parole board. The other issue in terms of the secretary, as it has been indicated in legislation that secretary should be secretary should be coming from the DCS. So in terms of the review of legislation, when we look at the composition of the parole board, that's what we'll be looking into, because it is legislated, so we cannot just do away with that without reviewing the Correctional Services Act. So whilst we are looking at the review of the parole board, as we have indicated that there are some sections that need to be revised in order for us to implement the reviewed parole system. So those are the issues that we'll also look into. Executive authority will also guide in terms of the parole system as to who should be involved, as you have indicated, Chairperson, that maybe the parole board should be in the minister's office, in the ministry. So those are some of the things that could be looked into. The issue also of the 3-tier system, as Minister has indicated, that we are also looking into it, because we have presented, but there are still other issues that are challenging with that 3-tier system. So we are still going to look into that and ensure that whatever that we'll be coming up with, even during further consultation, as the Minister has indicated that we are also going to have a summit, then we'll also receive some of the inputs and comments with regards to that. So in terms of people knowing about the parole system, we also had a launch on awareness campaign whereby we launched the parole system. We did that on radios. We also did that on taxi Wi-Fi. So we had a campaign whereby the GCIS assisted us in terms of launching that campaign on marketing of parole system. But that is on the existing parole system, so that people should know and understand what is involved, what are the requirements, because we do agree, Chairperson, that most of the people doesn't know, because even in terms of the questions that we keep on getting, people doesn't know the processes of getting parole and all that. So during that launch, we received quite a number of questions, and some of the questions are also assisting us in terms of reviewing the parole system. So we'll be utilizing all the findings that we got during the launch of the awareness campaign to ensure that we review our parole system. I would then hand over to CDC HR just to address the issue of the criteria that was amended. That is basically the criteria on learnership. Over to you, CDC.
Thank you, Honourable Chairperson. Thank you, Honourable Members, Minister, Deputy Minister, and thank you, Acting National Commissioner. I think when we were previously here regarding the learnership, we did indicate that the changing of the criteria in terms of the physical fitness assessments was the only amendment to the criteria for the learnership. We had a target of 30% female and 70% male. And during the selection process, as the females were doing the physical fitness evaluations, we realized that the females were struggling with the physical fitness evaluations. And therefore, the National Commissioner then approved the adjustment of certain aspects of the physical fitness evaluations in terms of the BMI, which was revised from 30.4 to 34 or less, and the 2.4 kilometer run, which was supposed to be done in 15 minutes, and we made it 18 minutes. The reason for that, it wasn't an arbitrary decision, it was for us to be able to meet our targets in terms of our employment equity targets. And why did we not then call other candidates who may have qualified? As I indicated in the last meeting, we were looking at expenses that are involved in conducting the entire selection process. So it wasn't easy to just redo the entire process. This was done on the advice of our biokineticists, having looked at the mean average of what the females were achieving in the physical fitness evaluations. I'm going to address also the other issues that were raised in terms of human resources issues. Honorable Ngaba had raised the fact that is it only a budget issue that we are struggling with in terms of filling our vacancies and the time frame that we are taking to fill the vacancies. It is not only a budget issue, although the budget issue is a factor. We have a range of challenges that we face. Firstly, we have manual systems that we are using. Ideally, we would want to have an e-recruitment system where we are able to process the applications on the e-recruitment system. However, we do not have that as yet. And then owing to the high unemployment, we have large numbers of applications that we need to process. For example, for the learnership, we had 1.2 million applications. Now, that in terms of just a project, I don't think anyone can teach you how to deal with that. The same challenge that is experienced with inadequate capacity and other components obviously is also applicable to the HR capacity, the people that have to process the applications. And it's even worse in the HR space because when we fill critical vacancies, we always prioritize the core business vacancies. So the HR capacity to deal with these vacancies is also very high. The inadequate budget does affect us in the sense that once you have an inadequate budget, you then have to introduce bureaucratic processes to control expenditure. And so not only does it limit the number of posts that you can fill and prioritize, but it also necessitates that you put in processes where everything is centralized so that there is approval of every step of the process before it is done. So the functioning of panels is affected. We have to get approval from a central place for those panels to travel to the different places that they need to travel. So then, like I indicated, we have large numbers of posts advertised at once and then being dealt with by the inadequate HR capacity and then the large numbers of applications. So it's practically, it's just, I'm just trying to shed light on some of the challenges that are being experienced. And then in terms of the parole boards being allowed to other employment, Honorable Sikopo had raised that. Yes, they are allowed to have other forms of employment. However, I think in some management areas, especially the large management areas, they are practically committed basically every day. But in terms of their contracts, nothing precludes them from having employment outside of the DCS. Then the reasons why the shortlisting was not done in KZN, the shortlisting was initially scheduled for April and then it was postponed. I think the challenges that I'm raising in terms of the challenges with the selection process and the recruitment process as a whole probably affected it here, but it has been now rescheduled for later this month. So that would address the KZN issue. The vice chairperson and the chairperson were shortlisted. It's only the community members that were not shortlisted. So I hope that covers that. I don't know if there's anything that I omitted regarding the HR aspects. Thank you.
Thank you. Deputy Minister, you wanted to add something?
Yes, Chair. Just to add on the issue of the recruitment, remember last time when we were here, we brought the report in terms of this recruitment and those challenges, but also to say where there were challenges. Hence, there was that delay to say clean the system of all the irregularities. And I've seen a memo that has gone out in the media to say The KZN one will not go in. It counted 3 regions. It's Limpopo, Gauteng, and Northwest, if I'm not mistaken. That would be going through, but also with the capacity of the college itself, so that there's phase 1 that will go in while they clean the other, because the delay of not taking them in now, it delayed the whole system, because when we came into office, the process was already 3 years? 3 years late. So hence that report we brought in that portfolio addressed all these issues. I think we've highlighted, and that is why when it was raised that there were challenges in terms of your BMI and other things, why we gave a full report as a department in terms of that. I think I wanted to just to clear that is the issue, because the other matter is to also maintain and upgrade our other college so that we can speed up the intake. But also, Chair, what I wanted to respond on is the issue that was raised by Honorable Moela in terms of the wrong convicted vis-a-vis showing remorse and be granted parole. Remember, as the department, we don't convict. We cannot say it's a wrong conviction. It's the court that deals with that. When somebody feels that they have been wrongly convicted, they have a way in terms of the justice system to appeal or raise their issue. But if the court has given Department of Correctional Services a person to serve a sentence, we deal with that. But that process of showing remorse vis-a-vis wrong conviction, it's not actually a mandate of our department, but there's ways of raising it with the court that that person, there's a process, I think. I wanted to highlight that. But also, there was a question in terms of the term of office. The minister has dealt with it, that currently stressed, but also to say when you check our act in terms of your section 74(7), it gives you, just section 74 in totality, it gives you that the minister may appoint, and the minister, if there's any irregularities or corruption or whatever that is raised against the member, may remove that member. In terms of if any decision of the board, sorry, 7.4, let me read it. 7.7. A member of a board may hold an office for such a period of the condition as the minister may determine. In this case, it was a 3-year, but also the minister may remove a member from office on the grounds of misbehavior, incompetent, and so forth. Where we are, we've presented the report, it's just that we were skipping. Some of these board members, their term of office lapsed last year, some of them this year. So it has not been a wide, there was a huge vacancy rate. As their term of office lapses, some of them, because some of them were appointed earlier than the 2024, then this kicks in the making sure of the requirements as raised by that committee to say we need competent people who may run this process, because there was a genuine concern to say take it out of correctional services. Let's have people outside yourself to look into this matter of parole so that it's independent and can take decision objectively so. So I wanted just to deal with that, Chair. Thank you very much. Or the appointment of retired officers vis-a-vis the youth. I think it's the same thing that the Minister and the Chair was raising to say, can we compromise the quality of people that we want rather than appointing people who are not experienced, who are not knowledgeable of our area, what it entails and what it can do. So that discretion as they advertise and apply, the minister will know exactly what is it that we're looking for and appoint people, because surely we cannot gamble with the issue of parole on a serious note. It needs somebody who is cool-headed, who's well-informed, who can take decisions, like to say they cannot be influenced by anything, but they will follow our parole system to the latter. If a person has not been engaged in the programs that leads them to be given a parole, they will not recommend to the minister. So their recommendation must supersede everything, and so that as a department we are not seen bypassing, so that we can just release people and people reoffend. So we are also pleading to South Africans that when they apply to be part of these parole boards, really they must say, I am serving, I must be beyond reproach, I must be serving the Republic, I must make sure that I work within the prescripts of the law to make sure that I don't release wrong people. Because if there's wrong recommendation, hence the minister will go out and seek legal opinion if he doubts anything, so that we cover ourselves also as a department. But the matter of parole, not any other person can serve in that board. Thank you.
Minister?
If I can just quickly add to that, Honourable Chair, we are in a process where the vacancies and where people are shortlisted, as has been actually said. And we had a situation where some of the applicants complained because he or she was not shortlisted. But the person was actually too much in a hurry, if I can put it that way. And the person has been shortlisted. So when those matters come to my desk, I will look thoroughly as far as the criteria is concerned.
Thank you very much. Members? No.
Chair, I have a question that wasn't answered. Can I?
Yes.
I asked about the whistleblowers who are exposing the abuses in your system. What are you going to do to protect them?
Thank you, Chair. I'm aware of the matter. We've looked into the case. All I want to say at this moment is that we must remember that the legal advisors are appointed by the Office of the State Attorney, not by Correctional Services. I have many other problems when it comes to the Office of the State Office. If you ask what we do to protect them, of course. I mean, if they are correct and right with the allegations, there will be consequence management and the person will be protected. If we can find that there is now a sort of intimidation or anything like that, then of course we will ensure that she is protected. So we're not going to take the person out of service and go and put it to special place like protected witnesses or anything like that. But the fact that she already came to our side as a ministry and raised the matters, and we've looked into that, we're busy with that, and we are finalizing the matter. But the main issue that I can say to the honourable member, just bear in mind, and I don't want to go in all the detail, that the legal advisors are not appointed by Correctional Services. Thank you.
Thank you. Members, anything else? Member Daniels.
Thank you so much, Chairperson. Now, this is a point in time where I'm going to ask for indulgence, Honourable Chairperson.
We just need to be mindful of time. We're already into lunchtime. I just want to bring that to your attention.
I'm fully aware thereof. Thank you. You see, the issue that I've raised, and now we're getting closer to the truth, is very important for us to entertain. Because we may say, no, this has only got to do with the new recruits that we're talking about. But where do we draw the line? Because if you can do it for the new recruits, you can do it in any other application. Because a president has now been created. Now, I'm also equally pleased that it has been confirmed by Correctional Services that the criteria was changed to meet employment equity targets. That by itself is worrisome, because no wonder. I almost said with all respect, but I can't say that. No wonder When we go into many state enterprises, then we ask questions. How did this one make it? How did that one make it? How can this one be in this? Because of these changes that we are making to suit employment equity. So my question then, through your Honorable Chairperson, I can't remember offhand the amount of applicants there were for this new recruit positions, but there was a lot, shockingly a lot. Excuse me?
1.2 million.
1.2 million applicants. Thank you. 1.2 million people applied for these jobs. So surely shortlisting is part of the process. Now, when we realized that there are many people who don't qualify, and because of them not qualifying, we're not going to meet employment equity targets. If we go back into the 1.2 million, I'm pretty sure there are others there who applied, who could have been called in, and those eliminated who didn't qualify. But no, we didn't do that. That by itself is a problem on its own. So my question then is, as uncomfortable as some of us may find these questions, I am going to ask these questions because it relates to employment equity. Were white people also exempted from this criteria when they failed to meet the criteria? Were there any Indian people who failed the criteria, who exempted, who then made it through the back door? Were the black African people? And my interest also lies with the colored people who didn't make it, who were then incorporated by the amended criteria. And if so, how many of each? Because it's critically important that we balance things here. Now, there's a reason why criteria is in place, and then we find it fit enough not to look at it. But you know what? I would have felt slightly more comfortable if they went back to the 1.2 million applicants and then sourced other people there, because there's no way that anybody can accept that only those on the short list were critically needed to fill those vacancies, when there were so many million-plus people that were not shortlisted, where they could find the people they were headhunting for to fill those positions. So that by itself is a problem. So I want to land, Chairperson. You will find that people who complain about what I'm saying here are probably the ones behind maneuvering this criteria to benefit specific individuals who they have earmarked to come in. And therefore, it is critical for me to get answers. How many colored people were considered? How many white people were considered? How many black African people? How many Indian people were considered? Because that will give me some sense of closure in understanding what went about here. Because I can tell you my gut feeling guides me here to say certain racial groups were targeted, and therefore the answer eventually came that is to meet employment equity targets. But I feel sorry for those other black African applicants. I feel sorry for the colored applicants, Indian applicants, if they don't want to bring white people in. I feel sorry for those who applied who were not considered. My answer is, my solution is, to the problem they faced back then, it wasn't a problem. You should have gone back to your database of applicants and found people there. The mere fact that you failed, refused, and neglected to go back into your database is because you've already committed those jobs to some people who applied. There's no other logical reason for me to think any different. And that is the problem that we have. No wonder I will say, and I really land on this because I speak very angry, Chairperson, like I am. I will land on this point. You know what I say? And I say this with all conviction. There are very few police officers that will catch me when they chase me. They can't scale a fence. They won't catch me because of this that has just happened here in correctional services. Increasing time frames for fitness, BMI indexes, and then we sit with a lot of people not fit for purpose. And then we are the laughingstock to the rest of the world. You can see on social media when they show other countries, people in security, how fit they are, the training they do, all those things, and they compare South Africa. They don't care. They don't compare Angola or Zimbabwe. They compare South Africa with those countries. And you can't help but agree with them that there's reason why we've become the laughingstock of this world, because of these practices that we apply here, because we're forced to bring specific people in when other people suffer in the main. We must stop this nonsense. So I appeal for really the minister and the deputy minister to have tea together and discuss these things. Because as much as we don't like to hear these things, we have to talk about it. It is not fair to all other applicants who aspire to get in, or at least had hope to come in. Then officials here, and we must find out, I see the National Commissioner signed that thing off, in consultation with who? The National Commissioner must come and answer here. What gave him the right to take that decision, or who was in the room and around the table when the decision was taken to sign such things off? Let's change the criteria to suit people that are here. You should have gone the other route and gone back to your database of applicants, and this would not have been here today. So I trust, Chairperson, that this is a very serious lesson for us to learn and for us to be completely vigilant when it comes to these, because a lot of officials here think that they control, they crack the whip. A lot of officials believe, no, you can't touch me because you're not going to meddle with administrators. Because we leave it to do the administration, that you do those things. And when I read in the papers about officials taking bribes for jobs, then I wonder what's happening in this directorate. For how is it then that you can change the criteria so much to bring people in when you could have gone to dig deeper into your database of applicants? But you don't do that. Are people being paid to give these people these jobs? I don't know, but I've got my suspicions. I thank you, Chairperson.
Thank you, Honourable Daniels. Seeing that a large part of the answer in the question that you posed involves lots of statistics, I think we would provide the department the opportunity to provide an answer in writing that they would send to SIA, and that would be then distributed to the committee. Thank you very much. Ms. Minister, Deputy Minister, thank you very much for availing your time. We've unfortunately now totally run out of time. I don't know if there's any last bite of the cherry that you would like to take.
I will be very brief, Chair. It's serious allegations. And of course, if we get the facts, I can assure the Honourable Member I will act on that because it's not acceptable. So you're quite right. Let's get the statistics and everything. Can I just, by concluding, say that where I was involved in appointment and part of the selection process, I already made a decision in one case on an area manager level. It was a white woman who was appointed. And on regional commissioner level, it was a brown woman here in Western Cape. And I said, that is how it's going to be. So we are looking at that. We must also understand, especially white people, I know, that they don't apply anymore for certain positions in government departments because they believe it's no use even applying because we are not going to get the position because of affirmative action. That's a political debate which we can have in the National Assembly. Thank you, Honourable Chair.
Thank you, Minister. Honourable members, Deputy Minister, Minister, DCS, thank you very much for your attendance. This meeting stands adjourned.